Have joined us already, so welcome to everybody. Thank you so much to Pilar and to the panelists in the last panel for an extraordinary conversation. I don't want to lose any momentum, so I think we should just jump right in. This panel is going to obviously have as a general focus that broader view that Pilar talked about, but the short term, medium term, and long term are merging in everybody's answers and analysis for obvious reasons. So I'm sure we'll hear a lot of the same themes. Our first speaker is Professor Robert Tsai. Professor Tsai is a professor of law and the Harry Elwood Warren Memorial Scholar at Boston University School of Law and an expert on so much in the constitutional arena. Welcome, Professor Tsai. Could you kick us off?
Sure. Can everybody hear me? Great. It's a pleasure to be with everybody. I'm going to try to do two things. First, I want to sort of provide some deeper context. I've been listening carefully to the first panel's wonderful commentary. And I also want to look ahead as well. And I want to do it by doing two things, putting this decision within the context of longstanding constitutional politics, and then also to talk a little bit about what we see in this opinion in terms of representing the variety of legal tools that are available to Supreme Court justices as they engage in decision-making as a form of constitutional politics. And I think once we do those two things, look at this decision within the context of constitutional politics, and we think about the tools that are available, this opinion really won't be all that surprising at all. Let me just start by first saying that I agree with others who have either said explicitly or otherwise that this is not an originalist ruling. It doesn't pretend to be. There's a little bit of history sprinkled in, but much of it is a more recent history. Instead, it's a kind of freewheeling national policy making by the Supreme Court of the United States, I think, for the good of the presidency. This is what 6 members of the court believe is the best way to protect the existing president and perhaps and all future presidents. And they've done it based on a malleable principle that doesn't explicitly appear, but everybody believes it appears, and that is the separation of power. So in other words, they're engaging in national policy making on top of and using this already malleable principle of separation of powers, where lots of different people have very different views about what it really means. And they're doing so shaped by what we know is the reality on the ground, that is that a supermajority of the justices' experiences and their priors, and that is that they understand the modern presidency as something that must be protected from all manner of annoying activities, including annoying political forms of accountability, say from Congress or independent counsel, as well as legal proceedings of all sorts, including those by state and local prosecutors. This also brings in, I think, and it helps us understand some comments made earlier about why we don't really see a lot of evidence of negotiation with the 3 liberals that remain. And I agree with Professor Hutchinson. There is indication that there is some negotiation among the sort of within the conservative bloc. This is a good example of their exercise of outsized judicial power to engage in this national lawmaking or national policy making. So they're negotiating amongst themselves, and it doesn't look like any real effort to gain the vote of someone like Kagan, who writes about the presidency, writes about the administrative state. They could have worked harder maybe to get her vote, but they don't need her vote. And so if anybody's surprised by the breadth of it, then I think this is what's going on. As others have mentioned, the text of the Constitution makes no mention of presidential immunity, and to the extent that there is any language that bears on what we're talking about, the impeachment clause explicitly contemplates criminal prosecution. And others have alluded to both the substantive dimensions of the decision and the evidentiary one. Okay, so what about constitutional politics then that I'm talking about? Here's the main point, and that is that lawyers who work for presidents, once they're picked to become justices of the Supreme Court, become justices who see the world from the perspective of presidents. This was alluded to earlier, I think, by Professor Kowarski, but I think The point should be underlined even more strongly. You've got a number of members of the supermajority of conservatives who worked for a president in one form or another, either in the Reagan administration, Bush administration, or worked on the campaigns of presidents. And they all came away from those experiences extremely protective of the modern presidency. Think of it this way: the modern conservative conception of the presidency is sort of Hamilton on speed. The office must be unfettered as much as possible in order to get the job done, especially now that the president has a shorter amount of time to do work than perhaps as originally conceived. The Federal Society has long had in its sights curbing investigations against presidents of all sorts. In the past, the things that have annoyed conservative lawyers and jurists are independent counsels, special counsels, investigations by Congress. So it's no surprise that a majority of the justices are champing at the bit, since they've already been worried about those investigations, to do something more about the fear of prosecutors initiating criminal investigations and around the country. As we see in Chief Justice Roberts' opinion, they worry not only about possibly distorting the quality of presidential decisions, even with the prospect of criminal prosecution maybe years later, but I think a number of them would probably agree with this point, which is that they probably also are worried about the quality of people who might be willing to run for president if this possibility sort of hangs out there. One thing, there's other things you can find. I'll just give you one example, but this is from Kavanaugh before he was ever a judge, I think. He openly said, was the Nixon tapes case correctly decided? A unanimous decision. And he once said, and this is in paperwork that was made available during his confirmation hearings, that ruling, the Nixon tapes case ruling, quote, took away the power of the president to control information in the executive branch. Okay, so this is just one example, but I think this is a view that's largely shared. Anyone who remembers the Iran-Contra affair will remember Lawrence Walsh's investigation of the Reagan administration, and I think someone like Chief Justice Roberts, who did work in the administration, as a lawyer, will have been shaped by what they believe was too much of a roving investigation, which contemplated the possibility of at least some criminal charges. All right, second point, which is what do we learn when we think about this case in light of all the various tools that are available to the Supreme Court as a modern national policymakers? Well, we know that sometimes the Supreme Court issues substantive rulings, such as they did recently, to protect Trump and get him back on the ballot. So there they interpreted the 14th Amendment to prevent states from enforcing the insurrection clause without additional congressional action. We've seen over and over that sometimes they like to resort to procedural rulings, such as deciding how quickly certain kinds of legal claims by presidents can be addressed. They sometimes manipulate standing rules, such as in the recent Mifepristone case, or they'll sometimes use rules of deference. This is something we see in Justice Robert Jackson's famous Steele seizure case, where he's kind of playing with different standards of deference. What do we have in this case? We have some principles articulated at a high level of abstraction. We've got no position taking on many specific things about how to apply those principles, kind of kicking the can down the road. But, and this is what's critical, clearly reserving the right to make those substantive judgments if the justices feel they need to later. There's one thing I want to also add on this point, which is that I see this missing in a lot of the media and early commentary about what this case's holding seems to be. You see it described as, okay, they've created this category of core powers there. The president is given absolute immunity. Then there are these other things that are official presidential actions, but not core. And there he's going to get some presumptive immunity. And my modification there is, I think they're not seeing the wiggle words that Chief Justice Roberts inserted in several places in the opinion. He said on that other category, what we'll call official conduct, but non-core, he said, we need not and do not decide whether that immunity for that category of things must be absolute or just presumptive. Later on, he says about that category of actions, at least presumptive immunity. To me, that suggests, and maybe this goes back to the earlier point about negotiating with conservatives to his right, that who wanted to more clearly immunize certain things that Trump did. I think here we just still don't know whether we'll get a later ruling. Should Trump actually get convicted of some of these things, where they end up saying later, we substantively now say that some of those things that are non-core but official actions, he also deserves absolute immunity for those kinds of things. That brings, let me give you an illustration. I know I've been abstract myself. The First Amendment. This is kind of a surprising thing. There's several paragraphs in this opinion that refer to the First Amendment. You're like, well, what does the First Amendment have to do with anything? It reminds me of something that Chief Justice Roberts did in a different case, again involving President Trump. Professor Hutchinson alluded to this earlier, and that is the so-called Muslim ban case, Trump versus Hawaii. A couple of things here. One, in that case, the court also said something like this: once you identify core constitutional power by the president, then you don't inquire into the motivation of the president. This is a way of making certain kinds of evidence and certain forms of inquiry irrelevant, short-circuiting those forms of inquiry. Now, in the immunity case, it's not just about, say, equal protection challenges to a presidential decision to block people from coming into the country, but they've now theoretically broadened this approach to all core powers, not just those involving national security. We don't know where this will go in the future. Second, in both cases, we see a mention of the First Amendment as a way of what I think shoring up controversial policymaking. We see this in other cases where the justices try to exploit what they believe to be a broad consensus among everyday citizens regarding free speech. In this case, we see lengthy discussions about how a president speaks today to the country, and in Chief Justice Roberts' words, touches on nearly every aspect of American life, again reminiscent of his decision in Trump versus Hawaii. In the Muslim ban case, Trump had repeatedly said derogatory things about Muslim people and promised to block them from entering the United States. And there they said, that's not relevant anymore. We don't look at that kind of evidence. Here, we have potentially far-reaching obstacles created by making it impossible to introduce evidence of Trump's speeches that might bear on his state of mind, say, in whipping people up and pointing a crowd up at the Capitol, right? So here's a sloppiness point. We don't really know what the effect of all this stuff is. Does this discussion mean that Trump's efforts leaning on state officials to find him extra votes are to be insulated for an additional reason? In the section of the opinion that talks about that, it kind of says on the one hand this, on the other hand that, and kicks it down to the lower courts to decide. They do mention the take care clause, which is, I hope others talk about this, suggesting that, well, he argues that he is doing, he's leaning on these, he's making these inquiries because he's got a duty to take care that the, voting laws are enforced. Here's another possible thing that Chief Justice Roberts might be signaling towards, that there might be some justices who might be willing to insulate these conversations on a different ground, that is the First Amendment, right? You see some other evidence of this possibility where they go back, they kind of bend over backwards, saying that conversations between Trump and Pence ought to be protected. But these are very sloppy. There are a lot of allusions to this stuff, suggestions, no clear legal principles or rules. Brandenburg versus Ohio, which is clearly on point, is not mentioned. What does that mean? Does that mean a president is more protected than the average citizen when they incite crowds to do illegal things? We don't really know. Are they open to constitutionalizing what we call the rhetorical presidency? If so, this is a purely 20th century phenomenon, and it would be incredibly non-originalist form of analysis to do so. All right, so let me just pause there, and I hope that provides some context, plenty of some of the things we've said, but also looks forward with some trepidation. Thanks.